Welcome back to Checkpoint. Now, today, of course, we are discussing the issues surrounding the judiciary, and we do understand come Wednesday, they will all be convening right here in the capital to discuss the happenings in the week. And like we had told you, we have a panel of legal minds today. Thank you, gentlemen, for joining us. There have been a lot of legal arguments back and forth. And honestly, for the ordinary Kenyan, each side sounds convincing. But for you, Professor, what do you make of the events over the last week regarding what's been happening in the judiciary?
I think there is a lot of noise about totally nothing. I've always argued, even on this forum, that either we become a country ruled by law in this constitution, or we are a country ruled by opinion. If you look at our constitution, section article 251, 1, 2, 3, it gives us the procedure for setting up a tribunal, in this case, the JSC, and of course, how Parliament should look at it, then finally how it should end up with the president. There are no options. Now, this procedure has been followed, and what the president was supposed to do is to set up a tribunal. I have read in the press, through the press, some people, politicians, saying that the president should have given it a political solution. How do you give an issue a political solution when there is a legal framework to handle the issue? So this is what I'm disputing. So as far as the appointment of the JSC is concerned, the president is perfectly right, and he has operated within the constitution. But where he went wrong is when he appointed members of the tribunal, members who have been associated with his own political wing.
All right,
so that is,
for you, it's the impartiality.
Yes, otherwise,
of the tribunal.
Otherwise, the appointment is legal.
For you, is within the law.
Yes.
Okay, all right, let's have the legal minds weigh in on this. Elisha, you disagree?
I fundamentally disagree, and I can understand why. Those of us who have been a bit of time appreciating proper approaches to interpretation of the Constitution, Professor's approach is actually the wrong approach, where you pick one article of the Constitution and you read it in an isolated manner, and you say, because of the text of this article, the president is right. That's actually the wrong approach to interpretation of the Constitution. The right approach is to read the Constitution as a whole. In fact, if you go to Article 258 of that Constitution, it tells us how to interpret this Constitution. It tells us that that Constitution must be interpreted in a manner that promotes certain values and certain principles. If you look at Article 3 of the Constitution, the president, like any one of us, is under a duty to defend and to protect the Constitution. Article 258 tells us that we must interpret this Constitution in a manner that promotes its values and principles, and one of the values and principles of this Constitution is the rule of law. It's acknowledged universally that there can be no rule of law in any society that can choose which orders of court respect and which orders of court not respect. Under normal circumstances, all other factors remaining constant, the president would have been right in Professor's estimation. These are not normal circumstances. These are circumstances where the procedure resulting to a recommendation to the president was done in violation of an existing court order which remains in force to date, so that we cannot read Article 251 in total disregard of the fact that that order of court exists.
So you're referring to the High Court order, that barred Parliament from discussing the conduct of the JSC members.
Exactly.
And so for you, the president acting on what Parliament said because Parliament discussed this in contravention of the High Court order
was perpetuating that illegality.
I would like him to note that that court order should be also be contextualized in the sense that the members of the judiciary are interested parties in what has happened with
court orders are not contextualized.
Yes,
a court order says what it says in law.
The problem they are interested parties because some of the members of the judiciary, the JSC, are advocates of the High Court, and you cannot overlook the chemistry that exists between the two teams.
So that is not a valid ground, unfortunately, in law for disregarding a court order. The valid basis in law is to go back to court and set aside that order, or to go to a higher court. It's not for the president to sit and say, now the order exists, let me begin interrogating the DNA, the chemistry of the person. No, that is not open to the president.
For you, it's obeying the court order.
Obeying the court order.
All right, Charles.
Even at our weakest, Yvonne, we must obey orders of court. At our worst in history, at our worst as a democracy, we must obey court orders.
Charles, what do you think? Was the president misadvised on this issue?
Yvonne, I don't think the president was misadvised. And I tend to differ with my colleague Elisha in interpreting this matter. I think if you look at the Constitution, the first article of the Constitution, which is the most important in terms of establishing the structure of government, establishes a government that is divided into 3 arms. There is separation of powers in this government. And these 3 arms are the executive, the legislature, and the judiciary. And each of these arms has a fundamental role and cannot cross over into the area of competence of the other arm of government. So the key issue has been when the court issued the court order, and was that court order legitimate because of the fact that it was purporting to injunct or to stop Parliament from undertaking its proceedings. And Yvonne, if Kenyans can just think back even to 2 years ago when we had Kenneth Marende as the speaker, he also faced similar attempts by the court to stop Parliament from doing its work. And he was categorical. He said Parliament cannot be stopped by a court order.
Okay, on that, let's bring in Elisha. They cannot stop Parliament from the proceedings. However, they can challenge the outcome of the proceedings of Parliament.
The most dangerous part of that submission is that it comes from Kanjama, an advocate of the High Court of Kenya, by saying, let us interrogate the legitimacy of this order. That's a political approach to the court order. The court order may have been wrong for all I care. The only option available for dealing with a court order that you don't agree with is you go back to that court and ask for a review of that order, or you go to a higher court and ask for prefer an appeal against that order. And even this is not magic. If we were to allow all citizens out there to decide which order is legitimate, which one is illegitimate, can you imagine from where you sit the kind of chaos that will bring in the administration of justice?
Charles, did the National Assembly, should they have looked at this approach from going to court and trying to overturn the injunction?
Let me contextualize, Yvonne. And I think there are some lawyers in this country who have got carried away with this principle that the only way of challenging a court order is to go to court. It has become a fetish.
So there are other ways?
There are other ways.
Such as?
And I'll tell you that first, to contextualize, we need to understand that court orders are derived from the jurisdiction of the court. And the jurisdiction of the court is established in Article 165 of the High Court, and what Elisha mentioned, Article 258 and Article 22 of the Constitution, the power of the court to intervene in constitutional matters. But these constitutional provisions on jurisdiction have to be balanced with the immunity provisions that are found in the very same Constitution. There is presidential immunity, for example, in Article 143. There is immunity of Parliament in Article 117. Even judges have immunity in Article 160, paragraph 5. So the question is, if the court issues an order summoning the president to answer for a civil matter, should the president appear? According to Elisha, and probably some lawyers who agree with him, yes, he should. But if you look at practice in many countries of the world, the president would simply send a letter to the court, refer to Article 143 of the Constitution and say, I'm not subject to your jurisdiction.
All right.
So the approach Parliament used is an approach that has been used in Kenya and in other Commonwealth countries, where the Parliament has just said, no, we cannot accept, because by going to court, we are already conceding to the court jurisdiction. So this is an issue that is not so clear-cut. And what I'm trying to say is that there are two very solid principles that are coming into conflict. One is the principle that everyone must obey a court order or seek to have it reversed. And the second is the principle that the courts cannot injunct Parliament. So the question is, when these two clash, which gives way? Separation
of powers. Professor, do you think that the 3 arms of government are playing their roles equally and that there's checks and balances of power, or do you think that in this case the High Court was interfering?
You see, the High Court, if you look at our Constitution and you look at Article 2, which has been cited, you know, the Constitution is the supreme law of the land. And once, if we have a disagreement, even with regard to the courts, or some people have disagreed somewhere, we go and ask, what does the Supreme Law say, the Constitution? The defense of this Constitution does not lie in the courts alone. I am a citizen, and I would not want to obey orders that are meant to interfere with the strength of the Constitution. So as a citizen also, I'll look at some of the orders. The orders that were given by the court were meant to make sure that Parliament does not move and also the President does not work, and then give the JSC a leeway to operate as they please. The dictatorship of the judiciary also needs to be checked, because if it is not checked, it's likely to interfere with the protection of the very supreme law that we believe in so much.
All right, let's talk about the JSC now. Of course, 6 members are suspended, and many are saying this will grind the operations of the court, of the judiciary, bring that to a halt. Elisha?
Well, it's important to appreciate that the JSC is an integral part of the judiciary that is responsible for policy and programmatic functions of the judiciary, not the day-to-day judicial decision-making of the judiciary. And therefore, to the extent that, and unfortunately, these two functions are interlinked. The judiciary requires policy guidance and programmatic layout to be able to effectively discharge its decision-making function. It is perfectly in order that tomorrow, Monday morning, magistrates will appear in their respective stations and judges will appear in their respective station, but that people may not realize in the short term that anything has happened. It is also possible that the members of the decision-making arm of the judiciary, the judges and the magistrate who resolve our dispute on a day-to-day basis, as they have promised, will down their tools to come and investigate, to come and interrogate. What does this?
It's certainly not an issue of finances, though.
Let me complete this. What does this mean to our function? If they do that, and from what you followed in previous news items, they come to Nairobi, all of them on Wednesday.
Yes.
You and I can bet that on Wednesday there will be no judicial function that the day-to-day, the average mwananchi consumes. To that extent, then you see a spillover effect of this decision to many other functioning of the judiciary, hence grinding it.
Be that as it may, without the JSC 6 commissioners who are now under probe, are we then saying the judiciary cannot function? Of course, this is what you said is as a result of the decision made. But without those 6 members of the JSC, are we saying the judiciary cannot function?
Well, let's put this. Certain functions of the judiciary cannot function.
Such as?
For example, the process of disciplining members of the lower cadre of the judiciary, who are the magistrates, who are ordinarily disciplined by the Judicial Service Commission, cannot be disciplined, because for the JSC to say discipline them, it must have a quorum.
And the quorum is how many?
It's 6 members, and we don't have 6 members as it were remaining in the JSC. So certain functions of the judiciary cannot carry on. Certain functions of the judiciary will carry on. Tomorrow, I have no doubt in my mind that I resume my functions in my office, knowing that I'm going to court to appear before judges who are going to be sitting.
You see, my brother is making a point, but we need not be blackmailed by the judiciary, that because the president has set up a tribunal, then the judiciary doesn't work, and some have probably threatened to walk on foot from Kitale to Nairobi. I don't know, because they say they're looking like they will demonstrate. What is critical here is that, has the president made a mistake or not? If he has followed the law, the price that we pay for delays in the courts is the right one, because it is going. In fact, what I'm seeing happening is that the chickens have come home to roost.
Charles, should we be willing to pay that price, as Professor says?
I think if the president has done the right thing, and that is the issue we are discussing, we must be ready to pay the price. When a few years ago, we wanted to tame the matatu industry and they threatened to down their tools, Kenyans were ready to pay the price. I think it would be intimidation if indeed the president acted correctly for members of the judiciary whose work is not being interfered with by the investigations into the JSC members to down their tools. Incidentally, let me just clarify that the chief administrative officer of the judiciary is actually the chief registrar of the judiciary, and there's an acting chief registrar of the judiciary. No financial or administrative problems can stop the judiciary from acting.
Because the chief registrar is the chief accounting officer, among other functions.
Exactly. And then for discipline of magistrates and junior officers in the judiciary, the Judicial Service Act actually delegates that power from the Judicial Service Commission to the Chief Justice. The Chief Justice is the head of the judiciary. The judiciary can keep functioning. The only thing they can't do, which of course is of concern to us as lawyers, is recruit fresh judges. And that is of concern, but we are ready to wait if that is the price we need to pay.
There's a danger here. One, here is a judicial officer, a judge of the High Court has sat and has delivered an order. And the topmost executive, the symbol of national unity, has disregarded that order. What comes into question is the authority of the court itself. I think it is simple to say. It's
some
simple
may
to
say
say
the president's hands were tied.
It is simple to say.
Because according to Article 254, he was bound by the fact that
which
Parliament
I think
had
that's where I started from, Yvonne, and I never get tired of going back. That is a simplistic reading of the Constitution. A proper reading of the Constitution will demonstrate to you that the president had no option in the nature of disregarding a court order. But the point I'm making is this. A judicial officer sitting has directed his mind and issued an order. The topmost executive, the symbol of national unity, the chief executive of this country, has disregarded that order. The question that the judicial officers will be asking, and if I was sitting in there, she would be asking is this: then what further authority do I have to issue an order against a petty bicycle rider riding a bicycle without a lamp, if the example that the citizenry are getting from the topmost executive is that of disregard of court orders? It's very unfair to say that to interrogate this is to hold somebody at ransom.
All right,
let me say something just to respond to that. I have in my documents here a document actually by the Chief Justice, or a report of the Chief Justice in 2011, after Kenneth Marende, the Speaker, kept complaining, why are your judicial officers trying to injunct Parliament? And the Chief Justice himself commented that they are making a mistake. It's not possible. The Speaker, Kenneth Marende, said they can't injunct Parliament. That order that has now been turned into a fetish was not even served on the president, neither by advertisement or otherwise. So even if you were to say you have to obey a court order, the court order must be formally brought to the notice.
Well, I don't know,
and that is not the issue.
Charles Kanyama may have a brief for the president, know whether he was served or not. You see, from where I sit, I don't know whether the president was served or not. You and I at least know the court order exists. Charles Kanyama wants us to believe the president does not know the order exists.
No, it's not a question of knowledge. I think the law is very clear.
Let me help my brother here. What he can do as a lawyer, because I'm not a lawyer, but I would like to invite him. If you look at the first question you asked me, I said the president was right legally, but in terms of constituting the members, he was wrong. And he could also be caught on that, because if you look at section Article 25, and everybody has a right to fair hearing. Read it with the 50, Article 50, fair trial and fair hearing. What the commissioners can do now is to get an injunction and ask the president, can we receive fair hearing if Ringera is the judge of this tribunal, when we had issues with it. So the legal process can still go on from that point of view, and maybe now an order can be issued to stop any proceedings until that is determined.
All right,
so that is really what we do, and I've said that we either become a country ruled by law and the constitution, or a country ruled by opinion.
But therein lies the conflict, where you say we want to be a country ruled by law where we disobey court orders. You know, therein lies the internal inconsistency in professors.
I would like this gentleman to remember the crux of the matter here, which is a petition that was brought to Parliament by one individual, Nicholas Mugambi, who had made claims of impropriety on the part of these 6 commissioners, because we tend to get forget in all of this legal jargon who followed what court order. Elisha, are we saying that the JSC cannot be investigated, because that is what a lot of Kenyans are saying, and this is an ordinary taxpayer whose money goes to funding this commission?
I'll be the last person to fault that Kenyan for presenting a petition. He's perfectly within his powers to present a petition to Parliament. I'll be the last person to fault a Kenyan. Number two, I did not say that the allegations leveled against the JSC were weak or they were frivolous. That is not what I'm saying at the moment.
So for you, how would we best proceed so that we can get to the bottom of the matter and find out what's really going on within the JSC?
Two things. Number one, the JSC is not immune from investigation. The JSC can be investigated.
And on that we all agree?
All that we agree. The JSC can at any time be investigated. That is not in dispute. The question is, every investigation, every process we undertake as a country must know that we are a constitutional democracy, must be anchored on the Constitution. Now, the petitioner acted well within his rights to present a petition to Parliament. The JSC Commissioners acted well within their rights to go to court and claim that their rights are violated. The merits or demerits of the petitioner's petition was to be determined by Parliament. The merits or demerits of the JSC's allegations against the process were to be determined by court. The court found that I have not heard, by the way, that petition is yet to be heard, the petition filed by the JSC in court. But it said, in the meantime, as we hear or we evaluate the gravity or otherwise of the claims by the JSC, stop this process. That is an existing order. So let us not mistake this to be saying that there are no legitimate claims against the JSC.
Yes, and Elisha, you clearly mentioned that the JSC, definitely should be probed if there are any allegations of impropriety. However, the commissioners of the JSC were summoned to the parliamentary committee and they snubbed.
Yes, that is the arrogance that you find in the judiciary. And if you look at what has been happening even with some members of the judiciary, the support of the judicial process is very poor. In fact, I expected that in March, during the presidential poll, one commissioner should not have been allowed to serve in front of judges he had helped to employ. And then he served, and when he was talking and submitting, he was extremely arrogant and he intimidated the court. So what you're seeing now is a situation where I say the chicken have come home to roost. And they have come home to roost because certain people are extremely arrogant and they do not want to be even probed.
Charles?
I think this whole saga can be summarized in one word: accountability. What we are facing is a crisis of accountability. This crisis of accountability was triggered when the JSC started investigating the Chief Registrar of the Judiciary. The Law Society of Kenya issued a statement and they said, look, under the Constitution, the body that has been given the mandate to investigate the Chief Registrar is the JSC. Let them continue with their work. There were allegations of bias. The Chief Registrar's advice, go to that commission, ask those commissioners who are biased to recuse themselves. There's an allegation.
Should the same thing be happening now?
Precisely, and that's what I'm trying to say.
If
that
they're
the same,
impartial,
exactly, the same approach should be followed as was followed with Gladys Sholei, it was a crisis of accountability. So you let the constitutional processes follow through, but anyone who has a concern goes to the relevant body. Now it became the turn of JSC to be investigated. They were to be investigated by Parliament, and it is so clear in the Constitution that is the organ they're accountable to. When they were summoned, they refused to appear. They went to court. They did not have the right to go to court to stop Parliament from proceeding with its function. And that is an area where, as lawyers, we may agree or we may disagree. But the fact is, the Constitution is so clear, it is Parliament to consider any petition to remove a JSC member. The JSC members want to go to court. Now that a tribunal has been appointed, they have an opportunity because the tribunal is quasi-judicial and the High Court has power to supervise. If the High Court decides this tribunal should cease its operations, it will stop. It can even be reconstituted. They can go there and raise issues of bias. But accountability must continue.
But even when you look at the issue of Sholei that my brother is raising, the Judicial Service Commission performed dismally. They didn't even think that, they didn't even show the public that they respect the rule of law. You could see the arrogance coming from the Chief Justice's office, the way they responded to things casually. At one time, she demanded that these things should be heard in public, and they said they cannot have it heard in public.
Yes.
I think this kind of arrogance
is a total mix of issues.
There's
a mix of issues.
Yes, that this has got nothing. Let's just sort of put it right.
Professor's philosophy is one. These people are arrogant. Let's treat them as they deserve.
No.
Just Kanjama's position, as I understand, is this: these fellows had no right to go to. I suppose that 2 minutes I will leave this studio, Charles Kanjama will be able to reflect and know that to assert that somebody has no right to go to court.
No.
Is a terrible misstatement. Is a terrible mistake. It's a terrible error in a constitutional democracy. That word, that phrase, that they had no right to go to court, can never come from a mouth of a lawyer of Charles Kanyama's magnitude. But let me put it this way.
I think he meant it, they had no justification.
No, he said they had no right to go to court. So what he meant is a different issue. But having said that, Yvonne, let me put it this way. Every citizen has a right to go to court.
Okay.
Once a citizen is before court, there are very many options available. As Parliament, I can go and raise a preliminary objection saying, look, as a court, you have no jurisdiction.
Okay.
Every court in this world has jurisdiction to determine its own jurisdiction, to find whether it has jurisdiction or not.
Okay.
The danger is this: we are confusing issues, and I think I began by laying the ball clear. I am not saying that the claims raised against the JSC Commissioners are frivolous or vexatious. They could have their own weight. I am not saying that the JSC ought not to be accountable. The JSC, like any other public entity that uses the taxpayers' money, must be accountable. The challenge is that the entire enterprise of seeking accountability must be conducted within the solid frameworks of the law. There is no justification in which you can conduct this accountability by disregarding court orders. That cannot be justified.
So for you, two wrongs don't make a right. Okay.
Yes. Let me clarify on that issue.
Please, we have a minute and we need to conclude your final remarks.
The crux of the matter is that according to Elisha, he cannot conceive of a situation where a court will not have jurisdiction to deal with the matter, and even jurisdiction to begin entertaining the matter at the preliminary level. In other words, at the level of beginning the inquiry and determining, do I have jurisdiction? And I think on that issue, we are totally opposed situation. Right now, I have spent probably the last 1 year pursuing a case through the courts. It is now going to the Supreme Court. And this case touches on whether Section 23 of the 6th Schedule of the Constitution ousts the jurisdiction of the court to intervene in matters of vetting of judges and magistrates that were in office under the old constitution. And the question is, did the court have jurisdiction or not? So what I'm trying to say is that there is a big body of authority on the fact that there are instances when the court doesn't have jurisdiction. Ordinarily, when the court doesn't have jurisdiction, you go to that court and point it out to the court. But there are cases when you cannot do it.
Right.
I'll give an illustration.
Well,
so that Elisha
I'm sorry, I might have to cut you off because we don't have time for that illustration.
But I'm happy with Kanjama's illustration. He says, I am at the Supreme Court challenging that jurisdiction.
All right.
That is important.
Okay, Professor, let's just have the final comments from you.
Yes,
if you can do that in a minute.
The Judicial Service Commission must face the tribunal, but I request that the President drops Ringera, Shamala, and Weda and Kilaka and appoints new people to probe them, because what we're interested in is justice. That is really what I would say for now.
A substantial bulk of the members of that tribunal are advocates of the High Court of Kenya. They are officers of court. They understand the regime of court orders. They should never take off on the platform on which they have.
So for you, they should decline to sit on the tribunal and hear the proceedings? Okay, all right. We leave it at that.
Sorry, let me give my final view, and this is about there is an objective and a subjective standard in regard to the people who are selected. Objectively, they meet the qualification under Article 251 to be appointed to serve in the tribunal. Subjectively, there may be issues of bias. Those issues can only come out if they are raised and considered by that tribunal.
Okay, all right.
So that tribunal should first sit, and the JSC members should appear before it unless they get a court order stopping the tribunal from operating.
Okay, all right. We'll leave it at that. Legal minds today debating this issue. Of course, we wait to see what happens on Wednesday when all judges and magistrates from around the 47 counties convene in Nairobi to discuss the way forward.